Hi, everyone. Harry here to talk about Donald Trump's opening brief, his set of arguments in front of the Georgia Court of Appeal. Now, this is the appeal of right from the denial by the trial judge, Scott McAfee, of the motion to disqualify Fani Willis. So you'll recall the whole kind of mess that occurred at the trial level once the relationship between Willis and Nathan Wade, who was trying the case, the main prosecutor, was revealed. Evidentiary hearings, all kinds of questions about when did the relationship start. Both Willis and Wade wind up testifying. And eventually McAfee, I think, gives a pretty tough order in which he says, I'm not going to require Fani Willis, and that would have been probably her whole office as well. You maybe could have carved just her out, but she's the head of the office. I'm not going to require her to recuse. If he basically said, it's you or Wade, Fani Willis, and said that, if Wade resigns and steps aside, something that was the prudent thing to do from the moment these, revelations came to the fore, because even assuming the absence of any kind of legal infirmity, the optics of her former lover, whoever Wade was at the time trying the case under her supervision, were ugly, to say the least. All right, but McAfee, I was critical of him, and I've generally been very complimentary of him for having this extended evidentiary hearing, because under the law, as I read it in Georgia, and it may be that I don't fully understand all the nuances, but I saw that the basis for recusing Willis needed to be some kind of bias or essentially a financial conflict, such that what really mattered here was not, has she been fully truthful with the court, or has she maybe committed any ethical violation by bringing on someone she's having a relationship with, any of those things, but rather for purposes of recusal, whether in some way she had compromised her position so that what would otherwise be her professional motivation to just fully and fairly prosecute the case would have altered. So the classic instance, and pretty much the only time that people could find recusals here, were in situations where a prosecutor or a lawyer would have a financial interest, let's say in the trials going on longer, much less in a certain result. That would be a classic kind of conflict that would just be untenable, because it would compromise and cloud what would otherwise be the ethical, tactical, legal judgments that you make when you're prosecuting a case. And that was why there was a lot of evidence offered about the finances involved in the romantic relationship between Willis and Wade. And the evidence when she testified, perhaps you recall her, kind of getting her dander up a little and explaining why she always paid in cash, and her father had told her when she goes out on a date, all those things. Why did they matter at all? Because of the possible suggestion that the relationship served her pecuniary interest in a way that would make her, would somehow cloud or compromise what would otherwise be her professional judgment. So let's say Wade had said, I'll give you $10,000 for every week you let me try the case. And that would mean that each week, when she might have a judgment to make about the best way to handle the case, she would be conflicted, because here was $10,000. So McAfee I thought, since that was really would have been the basis for recusal, I thought McAfee got way too into the sort of tawdry details, because the question was the financial entanglement of Wade and Willis as part of their relationship something that compromised either her duty to the court or Donald Trump's rights to be tried in a full and fair way. And the answer seemed clearly to be no, and that was the answer McAfee supplied. So let's say it was right, and this is how they got into it, that they would go away and they would take weekends. And she, adamantly said she evened it all up by paying him cash. But let's say it wasn't true and he, paid more than his share or whatever. Could that in any way be seen either actually or as a matter of appearance to compromise her judgment? And that I thought, and McAfee thought, was absurd, right? She's having a relationship, and the prosecutor is paying a little bit more than his share, or coughing up for the hotels or whatever, that would somehow affect and undermine her, what would otherwise be her vigorous pursuit of the case. It's imbecilic to actually claim that for Willis, the much bigger professional obligation was trying this case well. And so McAfee dismissed it. But he permitted an appeal to happen. And then the Court of Appeal, this has all been taken far more seriously in Georgia than it might have been expected by just reading the letter of the law. And it could be nuances of the law that outsiders like me don't fully understand, or it could be what people from Georgia have continually emphasized to me and others, which is the political situation there, especially involving Fulton County and Democrats and the broader Georgia and Republicans, is really roiled and sort of determinative of everything that happens. In any event, the Court of Appeal said, okay, we're going to hear this case after McAfee gave leave to do it. And then they reached down and granted a stay. So that means, for starters, as we've already known, no Fulton County trial. It looked promising for a while until the whole thing derailed with these allegations. So no trial for a while. And then depending on what happens in Georgia, crazy politics, if she's somehow recused, can they even put the pieces back together again with a different DA and from a different county? Even that, I would say, has to be counted as unclear given the Georgia landscape as we keep hearing about it. Okay, so that sets up. We have the appeal now, where Trump has said McAfee should have recused and thrown Willis off the case. And but it comes up, and he's filed his opening brief. And as I've said, the real basis in Georgia law would be some kind of financial impropriety or conflict involving Wade's previous entanglement with Willis. He's now off the case, of course, but something about it could have compromised what already happened. But they got nothing there, and there's really no basis for compromising or questioning what McAfee decided about a financial problem. So instead, they fight on a different battlefield, and that's what's going to happen here. And it guarantees that things are going to stay ugly in Georgia, because basically what they're saying is that this basis that McAfee was looking for shouldn't be the only one, and rather, when you have this kind of misconduct, and that is what they're calling ethical violations of having the affair, what they're lumping in Willis's probably ill-advised, self-serving speech where she gave her first words about the whole controversy in church, injected a fair bit of racism into the equation and the like. They're lumping that all together and saying it is multiple instances of ethical misconduct or otherwise improper conduct. You'll put them all together, and there's a significant appearance of impropriety. But that is not, first, it's dubious. Second, it wasn't found below by the trial court, and I don't see how the Court of Appeals can make its own findings. Third, it's just trying to completely transplant the basis for the appeal, because they don't really have what they need, which is some kind of solid forensic misconduct. They're calling it basically financial conflict of interest that erodes or challenges, even as a matter of appearance, what would otherwise be Fani Willis's vigorous prosecution of the case. So Fani Willis's office will now come in and defend, but they'll say none of this matters for beans. Nevertheless, it looks as if that will be the battleground on which this is fought. That all serves Trump's interest because it continues to shine the spotlight on Willis's poor judgment and bad behavior, even though that really shouldn't be anything that forces her to be recused from the case. But that's how Trump is going to want to play it. And again, we're already past the point of any hope of a trial in 2025. So it's really just a matter of, if she's recused, can there even be a trial going forward, period. So that's the long-term issue. And the shorter-term one is being able, in a way that just furthers and plays into Trump's bigger agenda of saying the deep state and Democrats are all against him, is having the kind of rhetorical force in an appeal that emphasizes things that Fani Willis has done that are not poor judgment, but really shouldn't have anything to do with recusal. So we'll see what her brief now says, and whether the Court of Appeal will sort of indulge this way of looking at it that Trump is proffering, and if so, how Trump exploits it in the broader political battlefield that he is using his prosecutions to try to inflame his supporters and portray himself as a victim of the deep state and the like. So there you have it, an appellate point that basically shouldn't go anywhere because it's not what you need to recuse, but that's how he's going to play it, and we'll see how Fani Willis responds. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.